Welcome back to the channel. This is attorney David Drew-Wicki from DRD Law, and I'm excited to talk to you today about one of my favorite types of cases, and those are possession cases. Traditionally, it's really one of two different types of possession, both in the actual items we're talking about, but then the legal principle that we're talking about. And what I mean by that is usually when I'm hired for a possession case, it's about the possession of a firearm or a weapon, a gun, or the possession of drugs or some other type of contraband. It's usually one or the other. And then what I mean by legal principle is there's really actually two types of possession under Illinois law. There's actual possession. This is probably the easier of the two to understand. Actual possession is when you're literally holding that item. It's in your hand. It's in your pocket. It's on your waistband, somewhere on your person where the police and then in turn the state's attorney at a trial, the prosecutors are going to say, you literally possessed that item. Be it the drugs or the gun. They were on your person. You were holding them, actually possessing them. And there's a certain way of attacking that type of case. And then there is what's known as constructive possession. And constructive possession is a legal theory where the state, the police, the prosecutors are going to treat the possession of this item, again, usually it's gun or drugs, that isn't actually on your person. It's not going to be in your hand. It's not going to be in your pocket. It's not going to be in your bag. That's right on your backpack or something like that. It's going to be near you. The most typical example or most common example that I run into are individuals. They're driving a car. They're pulled over for any number of reasons, not wearing a safety belt, that they were speeding, they rolled through a stop sign or a flashing red or any other, the multitude of ways you can be pulled over. And then the police search the vehicle for, again, one reason or another. Most typical example at this point is that an officer is going to say that they smelled cannabis or marijuana, that they smelled that it was either freshly burnt or just fresh cannabis, that there are drugs in the car. And under current Illinois case law, that's enough for an officer to search your car. And then when they search the car or they search the area that you're in, they find a gun or drugs underneath your seat or somewhere else in the vehicle. And they're going to then argue that you constructively possessed that weapon or those drugs because you were near them, and then they are going to at least presume, assume, or argue that you knew that the drugs or gun were there. That's constructive possession. Now, how do we attack those types of cases here in Illinois? Well, when it comes to actual possession, it's difficult because it's tough to say, well, you didn't have that item in your hand. You didn't have that item in your bag or in your waistband or in your pocket because it was either there or it wasn't. Maybe there's an argument that it was planted or somebody's lying about that, but that's tricky and difficult to prove. So in an actual possession case, usually the analysis has nothing to do with whether or not the item was actually there, because that's going to be assumed. It's, did the police have probable cause at one of two steps in the process? When they stopped you, were you walking down the street? Were you in your vehicle? Where were you and why were you stopped? Did the police have probable cause to stop you? That's the first bit of the analysis. Did they have probable cause to stop you? Even if they did, again, let's assume for purposes of argument that they actually had probable cause to stop you or to stop your vehicle or the vehicle you were driving in or a passenger in. Did they then have probable cause to search you? These are what are known as Fourth Amendment issues, improper search and seizure, at least arguably improper search or seizure. If it can be borne out at a motion later on, after the day of arrest, after you've been charged with an offense, that the police did not have probable cause or reasonable suspicion to even stop you, to then take the next step, to then have probable cause to search you, that can be a basis of a motion. And if we're successful within that motion, if we can convince the judge that the police violated your constitutional rights by illegally searching or seizing you, a seizure can be just the stopping of your person or your vehicle, then it can be argued that anything that the police found after that improper stop or after that improper search is fruit of the poisonous tree and should be suppressed. And if the police or the state in turn cannot bring that evidence in, that you had a gun or that you had access to a firearm or contraband of drugs or something like that, well, then the case will ultimately be thrown out because the state doesn't have the evidence to move forward. They don't have that gun. They don't have those drugs. So that's typically the way we attack an actual possession case. There could be some other nuanced bits depending on the evidence in your case and the facts of your case. But generally speaking, an actual possession case we're going to attack by way of a Fourth Amendment motion, assuming the facts are there that allows us to make such an argument. Constructive possession is a little more interesting. These are the ones, again, generally speaking, that we have more success with in trial because, just as a starting point, the police, their witnesses, and the state's attorneys are not going to say that you actually or literally possess that gun or those drugs. They're not going to say they found them in your pocket or in your hand or anything like that. They're going to say they were just near you. And in order to prove that, again, there's really two main elements: that you had knowledge that the gun or the drugs were there, and then number two, that you had immediate control and exclusive control over where that gun or where those drugs were found. There's a great deal of case law that breaks down what these terms mean and go through a number of different factual scenarios where if the gun or drugs were in a car, if gun or drugs were found near a person but on the street or something like that. But the state has to prove those two elements. Usually the strongest argument when attacking a constructive possession case will be the knowledge component. Did the defendant, did the person who's accused or charged with this crime, did they have any idea that that gun or those drugs were there? And that proves to be difficult for the state, though they can rely, they being the state, the prosecutors, can rely on circumstantial evidence. Now, circumstantial evidence, what is that? These are bits of evidence that would cause a trier of fact. The trier of fact is a judge at a bench trial or a jury at a jury trial. They're the ones who make that ultimate decision at a trial about what is true and what is not. What facts they're going to accept. So the best example of circumstantial evidence in a constructive possession case is that you were pulled over driving your own car and that there was a weapon found underneath your seat, the driver's seat, that it's going to be presumed that you know what is in your vehicle, that this is your car, you're in sole control of the car. If you were the only person you were driving, you're the only person in the car. They're going to say it's presumed you know what's in your vehicle. It was immediately underneath your seat, so you had immediate access. There was no one there to stop you from gaining access to that gun or contraband, again, if it was drugs. Now, if the gun is found somewhere else in the car, that starts to soften the state's case. However, one of the circumstantial elements will begin, is it your car or is it somebody else's car? That's one of the first questions I'll ask when doing a consultation on a constructive possession case is, were you driving somebody else's car? Was it registered to you? Was anyone else in the car? Where was the weapon or drugs found in the car? Was it in the front seat? Was it in the back seat? Was it in the trunk? Was it in a locked compartment? Where was it? Because these are the circumstantial bits that matter. Now, direct evidence that's beyond circumstantial, this is direct, maybe physical evidence, would be if they found a gun, well, did they swab it for fingerprints? Did they swab it for DNA? Did they swab and look for gunshot residue or anything like that would be on your hand or on the weapon itself as it relates to DNA and fingerprints? Naturally, if the state is arguing that you possessed a gun constructively, even again, it's not on your person, they're going to say, well, your fingerprints were on that gun, potentially, or your DNA was on the gun. potentially, and that's direct evidence that you had knowledge of it, you had possessed that gun in a literal or actual sense at a different point because your DNA or fingerprints are on it. These are all of the things we're looking at as a defense attorney to attack a case. Does this evidence exist? Does it not? Are there fingerprints or no? Is there DNA in the gun or no? Whose car? Where was it found? Again, these are all the questions we're looking at. And of course, just like we talked about with an actual possession case, there still can be potential Fourth Amendment issues where we're going to look at the stop, be it of your person or your vehicle. We're going to look at the search, again, of your person or of your vehicle. Was there probable cause? Did the police have a higher enough belief that some sort of criminality was taking place? Did they have a reasonable suspicion to stop you? Did they have probable cause to not need a warrant in order to search your car or to search your person? These are things that are very, very fact specific. They're case specific, but those are things that a trained criminal defense attorney is going to be looking for and looking at in order to get the best result for you, the client. Because if we can short circuit a case even before going to trial, because we have a Fourth Amendment motion in an actual or constructive possession case, that's the fastest way to beat a case. We're no longer waiting for a judge or a jury to hear out all of the witnesses, to hear all of the evidence. We're just saying constitutionally, legally, the police did something improper. The evidence should be suppressed and that you should win the case and the case should be dismissed on the front end. If those constitutional arguments aren't there, be it in an actual possession or a constructive possession case, then we get into the fact-specific details of your case itself. Goes back to what we talked about earlier. Where was the contraband? Was it on your person, or is this a constructive possession case? Was it in a car? Was it in a bag? What else was in the bag? Was there an identification? Were there male or female clothes in that bag? What's tying that bag to the person that they're charging with possessing that gun or contraband? There are so many bits of information that go into a case like this that, of course, it's tough to explain every possible set of facts that there could be. But that a trained criminal defense attorney knows what they're looking for. They know what's persuasive and what's not, what will meet the burden for the state and what won't meet the burden for the state, which means we as the defense are that much more likely to be successful. Gun possession, drug possession cases really run the gambit, from low-level misdemeanor offenses up to the most serious offenses, Class X felonies, Class 1, Class 2 felonies, and so on, that can require IDOC or the Illinois Department of Correction prison time. They're very serious cases, but at the same time, these are some of the best ones for a trained criminal defense attorney to attack because we know what we're looking for. I have handled quite literally hundreds of these types of cases through my career. Oftentimes on the immediate or initial consultation, I can get a beat on just how strong or how weak the state's case is against an individual. But it takes getting into the evidence. It takes getting into the discovery, seeing what's on body cam, seeing what statements, if any, my client has made, and going from there. We'll have videos discussing more about the Fifth Amendment, your right to remain silent, and what questions that you do or do not have to answer, and under what circumstances does the Fifth Amendment really kick in. Miranda warnings, as most people understand them. We'll get more in depth on another video, but for this video, for purposes of possession, again, my advice is always to answer as few questions as necessary. Give that biological and background information, your name, your identification, provide your insurance if you're driving a vehicle. But that would be it. Do not discuss what may or may not be in the car. Do not make admissions about other items that may or may not be yours. This can go to clothing, mail, bags, other items that eventually the state or the police will try to turn against you as being your own property. And because that's your property, other contraband that might be found in other parts of the car should also be yours. So it's answering as few questions as possible while also remaining positive and being polite, because the time to argue your case isn't on the side of the street. It's not when you're pulled over and the police are perhaps tossing your car or checking your pockets and going through your bags and belongings. Maybe that search is legitimate, maybe it's not, but you're not going to win that argument right then and there. Save it for another day. Choose your words carefully, answer as few questions as possible while being polite, while being professional, understanding that you can give my firm a call or any criminal defense attorney, and that we're going to look at these facts and make the argument the right way in the right circumstance so you can get the best result possible. Because again, even if you're 100% right on the side of the road, or when you're walking down a sidewalk or you're stopped somewhere else and you're searched, that isn't where you're going to win the case. Again, even if you're 100% correct, you're not going to win the case then and there, but you can win the case later because you otherwise kept your mouth shut. You didn't say something that you're going to regret later. You haven't committed yourself to a story. You haven't made admissions about things that you probably should not have because you kept things simple. You kept things to answering questions that you have to answer and nothing more. Again, possession cases are some of the most common things that I see in Cook County and in Chicago, but they're also the ones that are most beatable, either constitutionally with a legal argument or factually with the evidence in your case, the facts of your case when it comes to an actual or constructive possession case. If you have questions, by all means, contact the firm. This is something that we, again, handle hundreds of throughout the years. We're intimately familiar with the case law and statutes that apply to this type of situation and what makes a good stop, what makes a good search, and then alternatively, what makes a bad stop, what makes a bad search, and what facts will or will not work at a trial. So contact the firm right away. Know that you're in good hands. These are cases that we can and do win on effectively a daily basis. Thanks again for listening. If you have any other questions relating to criminal law, leave a message, contact the firm, or directly contact me. I'm more than happy to do other videos and topics such as this, just trying to instruct and inform the general public through my years of experience as a criminal defense attorney in Chicago, handling hundreds of trials and being in the courtroom each and every day. Thanks a lot for stopping by. Appreciate it. You have a great day.